No, Your Honor.
Specifically as it relates to speaker identification. Those were the matters referenced in the motion, noticed for the motion, and testified about already. Otherwise, again, it's not subject to a prior analysis under the McCoy decision. It's a decision if it's advanced if and when a transcript is alleged for juror use. But it's well outside the scope of the prior hearing, which I assume is why it wasn't included in the motion.
Your Honor, I'd like to be heard on that, and it's going to take us a little while to do that. We got that motion this morning, and I'd like to talk about some of the case law and talk about the history of this case in that context. So we can do that.
Can I ask you a question, sir? Well, it might be an inconvenience, but if we were to continue this portion of your testimony, and I could take up the objection later today, and then have you available if we need you to give more testimony at the
I'm sorry, Your Honor, but I think you said you're going to give it back to them, and then you're going to revisit me later today?
I was going to let them go forward with the matters that are not covered in the state's objection, and then I'm going to hear the state's objection and argument about that, make a decision as to whether or not we're going to continue to look again. So are you available this afternoon?
Your Honor, I have another
We'll go
suggestion.
forward now, but then we may need to again this afternoon. Would that be something you'd be available for?
I'm yours for the day.
I have another suggestion. We can simply proceed with the testimony, and then the court can sort it out later, whether or not it's something that should be taken into consideration in its ruling on these matters.
Then the state's going to admit each thing that's being said, and I'm going to have to make a decision.
The overall objection, Your Honor, is that witnesses that claim to have identified speech on the recording, that prepared transcripts of that speech, the state claims is not a proper subject of this proceeding. And we believe it is for lots of reasons. And what I'd like to do with this witness is simply confirm, as he's already said, was he able to identify speech? What was that speech? And was there no other speech? And then we know what it is, and he's going to send us the actual transcript of the speech, I assume, with a marker where on the recording this speech occurred. And
The state's position is twofold. And again, as a court in written objection, that is a matter that is well outside the scope of pride in general, because you're talking now not about speaker identification or methodology. Now you're talking about what is and is not audible on a tape, which is governed by a completely different set of case law than the Frye standard. It's not subject, as I think the McCoy case makes pretty clear, to that analysis. So that's my first objection. My second objection is we're now asking the witness to, again, go ahead and engage in this, and we would be quarreling over potentially matters which the state has not set forth as intending to present in evidence yet. The state hasn't submitted any transcript for consideration or publication to this jury, and unless and until that happens, it's something that's really not right. We're arguing about things that may never come to be. So it's premature, which is why I take it was left out of the motion, and which is why it would not be a proper subject for the motion. Long way of answering the question. I apologize.
briefly, the history of how this issue came to be. I have to sort of try to remember the sequence of events, but first of all, prior to today, we had no idea that this witness had generated a transcript where he believes he has identified speech as distinct from screams. And I'm going to talk with him before the day's over about whether he used those words that he believes he's identified as part of his analysis regarding who spoke those words or who was screaming. That's a subpart of it that relates specifically to this witness, and it is clearly involved in the Frye hearing. Mr. Manti suggests that it's premature. Well, that's what Fry is. It's an opportunity for the court to hear the methodology, the application of that methodology to the specific facts of the case to render a decision whether it's admissible for the jury to hear. So that's the overall context. The history was that on sometime early in the case, Mr. Owen was identified as, I think, a B witness, maybe a C witness, not an A witness. We had conversations over the intervening months between then and now whether Mr. Owen would actually attempt to be called by the state. And recently we were told yes. There was never a commitment until within the last couple of months or so that yes. There is a witness that is subject to these proceedings today, Harry Holeen, who is from the University of Florida, who did a separate methodology. The court has that report. Where
Oh, the
It's
state.
it's actually one of the states, yes.
Yes, yes, and that's Dr. Harry Holeen and Dr. James Harnsberger's report that basically is inconclusive, but the state is seeking to advance their opinions notwithstanding. So, and I'd have to be reminded as to the sequence of the events, but we received notice under the court's order disclosing witnesses of Dr. Holeen's involvement in the case officially sometime in late March, I think maybe by the 26th or 27th. We got a report from Dr. Holeen sometime in mid-April, 14th or 15th, somewhere around there, and then he was deposed, as Dr. Harnsberger was, near the, I think it was April 19th. We also received the name of Dr. Alan Reich, R-E-I-C-H, around that same time. We got and then we filed a motion for this Fry hearing, as I recall. And the state responded and said, no, we don't need a Fry hearing because all of this methodology has been well established for decades. And we filed a response to that. In the meantime, not until May 10th of this year did we get Dr. Reich's report, where Dr. Reich now claims that he can identify not just the speaker, but also identify speech that no other expert has identified, and apparently not even Mr. Owen has been able to identify this speech. So we got additional follow-up from Dr. Reich. We learned at his deposition on May 24th or 25th, I think it was, may even have been later than that, that he had done another report, and that he had done one when he was hired by the Washington Post, and he provided that to the state when they engaged him no later than July of last year. We didn't learn about that report until his deposition, which isn't complete, and in fact his work isn't complete, as we've explained to them. Background, we're still pedaling as fast as we can just to understand what direction this is headed, and this witness has identified speech. He claims to be a voice identification expert, so I think it's only reasonable that we be able to explore what speech he claims to have identified, and frankly, to compare it with speech that other experts have claimed to identify, perhaps later today. The point is that he clearly prepared a transcript, and that clearly entered into his decision as to his opinion here.
Evidence was provided, she's not commenting on another expert's testimony.
We could.
But he has prepared, and he has the capability of preparing a what you refer to as transcript, and he refers to some words that he's able to pull up on his computer, I could deal with that separately. And if you'll give me a moment, Mr. Owen, would it be possible for you to recreate that document and email it so the attorneys in the court can have a copy of it and go forward with your testimony?
Are you talking to me, Your Honor?
Yes, sir.
I can do it right now.
Okay, so how long will it take you to do it, and how are we going to provide it? Do you have somebody's email address?
I'm sorry, you cut out.
Email address?
Yes, I don't want to give my email address over national TV.
I don't want your email address. My question is, do you have one of the attorney's email address?
Yes, I can send it to Rich again right now.
Okay, if you'll send it right now, we'll get it printed out. We'll take a few-minute recess. The attorneys will have an ability to review it, and we can go on with that aspect with it. But
Right. Show.
evidence, you're not allowed any expert to comment on another expert's report.
Well, I think we can do that in the context of a Fry hearing. I agree it may be more limited before the jury if any of this evidence winds up being admitted, but that's...
Why don't we do this in this step process? Let's go ahead and get that email to Mr. Manti, get it printed out, have counsel in the court the ability to review it, and then we can move on to the next.
And while we're at it, the document that Mr. Owen refers to from NIST, we'd like to have that too.
The ability to fax or email the NIST document that you refer to Mr. Manti,
Yes, Your Honor.
if you will do that also.
Yes, sir. Yes, I will.
Kind of stand by with us. We'll give you opportunity for it to be printed out and for the attorneys to look at it.
That's fine.
Your Honor, if I may, just one last time in response to what you just said, we are now going to be talking about sort of product, not methodology. We are now discussing their opinion as to what may have been done, as opposed to anything that's covered in the motion, where they want to know about methodologies as it relates to the identity of the person making the noise, whatever it is, as opposed to going line by line or word by word through what any person, this expert, another expert, Dr. Reich, anybody else might think. Again, that's why that would dramatically open and put in unfamiliar territory the scope of a hearing like this. This is designed about methodologies, not...
I don't know what documents that are going to be emailed to you or what they refer, what they're going to indicate. That's why I'm having an email, take a recess, that's what will happen. We'll be able to have a discussion hopefully about that, maybe we can work that out, come back.
Yes, Your Honor.
Thank you, Judge.
Okay, before we recess, all that.